Welcome everybody to the New York City Bar Association's second series of the Emerging Legal Paradigms event. Today we have an incredible intergenerational roundtable discussion for you. We're going to be talking about conscious contracts, the purpose of contracts, and the future of law. So today we have a discussion around the different generations of legal practitioners we have here with us, who are going to be covering the purpose of contracts, the transformation of their journeys through the law and negotiation, and how these participants envision the future of law. This roundtable discussion is going to be an engaging self-moderated conversation between all of us with space for Q&A at the end. So with me, first of all, I'm honored to have at the New York City Bar Association, Alalá Linda Alvarez, who's the author of Discovering Agreement, Contracts that Turn Conflict and into Creativity, and is the co-creator of the Conscious Contracts process. I will also be part of the roundtable, not only representing here the Senior Lawyers Committee. And my name, for those who don't know, is Jacqueline Horani. I'm the founder of Horani Law, PLLC, and I'm also a visiting law faculty at Quinnipiac University. With me today are two of my students, Brittany Mancini and Gabriel Cassillo, who are both law students at Quinnipiac University School of Law. So we'll have a moment. I think we've got most of the people jumping into the room now. So we're going to go ahead and dive into this. I want to give everybody an overlay of how the framework of the Zoom call works. So you see on the screen here, all of us as the panelists. You should have the chat feature available. If you don't see it, there's a button at the bottom that says More, and you can click on that to open chat. When you chat, you should be able to message everybody who's attending here. So we want to see some conversation, not only of your interest in the program or any ideas you have pop up, but feel free to talk to each other throughout the conversation here. You want to make sure that the message says to panelists and attendees. If you want to send a question for the Q&A portion, there's a Q&A button. And when you click that, that should pop up an opening there. And Trudy, thank you so much. I just gave an overview of the event and the panelists, but if you want to join us to tell us a little bit about the Senior Lawyers Committee and what you're excited about for this event today.
Okay, I thought this started at 12:30, so I'm sorry. I just got a DTAP shot. So
no worries, we're glad you're here.
Okay, I'm sorry. Yeah, so the Senior Lawyers Committee is a committee of not all seniors, as Jacqueline is a member and is not senior in the usual terms. However, we are reaching out to engage younger people, as this seminar shows, because senior lawyers have a perspective that may be useful to the younger lawyers and emerging lawyers. So our focus is on presenting programs that will pique some interest in usually public affairs and affairs of law and the practice of law as one gets older, and to see how things can change for the next generations. So I'm very glad to be here. I'm sorry I was late. I had the time wrong. So I guess we can start. Should we start, or is
yeah, we can go ahead and start if you want.
Okay.
Trudy, and we'll just dive into the conversation.
Yeah, I would like to present, since you presented everyone, you named everyone. So I just want to say that this idea of cooperative or conscious contracts is something that is, I'm not a transactional lawyer, but in law school, it did strike me that you start to make a contract from the point of view of breach. Why do we do that? Wouldn't you think that a contract should be made from a spirit of cooperation? Because both parties want to get something out of it, rather than hit each other on the head with, well, if you don't do this, I'm going to do that, before you even start. So I'm very glad to present this seminar on this panel. Actually, it will be an ongoing discussion on conscious contracts, which I hope will embody a new way of looking at the contractual process and negotiations to finalize one. So who is going to speak first? Is it?
I think we're all going to be jumping in here, Trudy, but I think that's
Okay.
the perfect point to start on really what is the role of contracts. And so for the audience, you know, I think Trudy started off with this important point. Why do we come from this perspective of breach? And why do we come from this sort of adversarial position? So Alalá, if you want to jump in and just give some thoughts of what you see as the role of contracts, or what we're even doing when we're trying to create a contract in the first place.
Well, that's a great question. For me, like Trudy was saying, the idea of understanding ourselves as being opponents when we're trying to build a relationship and do something together doesn't make a lot of sense. But there must be a reason to have a contract, right? And it's basically, it seems to me, and I've always thought that it's about clarity, right? About who's going to do what when and what it is we're doing together. It's about predictability, being able to trust that what you expect is what's likely to happen, or you know when things are going to happen, and accountability, that question of you know, what if somebody doesn't fulfill their obligations, then what are we going to do? And that all comes down to safety, right? It's just basically, we want that contract document to provide a container for this relationship that's going to create safety. So that's, for me, that's what I think a contract is really about. And I'm not sure that you know, I get asked a lot by my clients when I say, you know, let's try doing this from a different perspective, this conscious contract idea. And they say, well, is it safe? And I say, well, are you safe now? Is the way we do it now safe? You know, I mean, really, and what is it that we're wanting to, what makes something safe? And in the book, I propose a definition of safety, which is having sufficient predictability so that your expectations are reasonably assured. Now, obviously, we live in a world of uncertainty and disruption in the marketplace, and it's dynamic. So we can only hope for reasonable, right? Reasonably assured, so that we can plan and venture with confidence that that it will happen? No, but that we'll retain the power to take a meaningful role in responding to changing circumstances, and that we'll have an equal voice and be treated fairly should something like disruptive change occur where we need to deal with a conflict. So that's my idea what safety is.
Yeah, I love that. And I just was thinking about, you know, before going into transactional practice, I was doing litigation, and thinking about the way we came to settlement agreements and how we were drafting and going through that process is so different than the work that I'm doing now. And I don't think it's because it was litigation versus transactional, but it was one of very adversarial start. It was a very, we are each entrenched in the ground, fighting against each other, and having to defend our clients against each other and fight for what we can get out of it. And I think that's shifted so much in my work to what I'm doing now, which is, you know, where can we find alignment? And if we're making an agreement, everybody needs to understand what's in the agreement. And why are we wasting our breath to write something down? It's because we both hope that we're both going to follow through on this. So what can we do instead to come together on that part of it and make it so we actually follow through on it? And it's such, like, for me, it's turned it on its head, that perspective.
Well, it's the same. It's that thing of shifting from trying to seek advantage one over the other and have this combat over in a kind of a zero-sum mindset versus coming together to co-create, because we can see that doing this together is going to be better for all of us. than doing it separately or with different partners. And so what can we put in place to support that and sustain it and to give it the best chance of success going forward? And that is a whole different way to build a relationship. And when you come to the final document, you don't have, as is often the case in the conventional situation, you don't have people who are feeling like there's been a win or a lose at this level at the start of the relationship, like, you know, that they're trying to even a score before they even begin. That's just, to me, that's nuts. It's just nuts.
As the law student, I hear contracts and I'm taken back to like my first semester of my first year of school, and it's like like triggering. But what happens is I think so often of the cases, and it wasn't about like drafting the contracts or how to make a really solidly understandable agreement that the parties are going by, but rather all of these cases that we're studying is like, oh, things went wrong. Like, we're here because that contract didn't do what we thought it was going to do. And then there's so much time spent on, well, this is what I thought it meant. This is what you thought it meant. Who's right? And it was very time consuming, right? It takes a lot of energy at the back end to try to recreate what people thought was going on at the beginning, when there was a lot of excitement and like possibility, and like you know, the agreement was fresh and new, and everybody was hopefully in a good place to get along. So when I came into this conscious contracting area, what occurred to me was like the agreement is still there. You know, you still have like what everybody is expecting to happen, but instead of focusing on like when this goes awry, a lot of the energy is focused on, let's make sure we're clear like on the why and the how and what's important to us in this contract. So that way, when things don't go as we expect them to, because life never goes as we expect it to, we have a really strong foundation on the front end of what I expect, not necessarily a raw number or a specific date, but a way of being in the work I'm doing that allows the two people to say, you know, you didn't get that document to me by this date, which is what we agreed on, but I know that that's part of your value system of you're always timely and punctual and communicate when something is awry. So now I get to check in with you instead of filing something in court because one thing wasn't as expected in our agreement. I mean, that's a exaggeration.
Yeah, I think a really important thing that you're putting your finger on that I'd like to articulate is that in the conventional and in your classes, we're taught that what the contract is for is to look backward. It's to look backward and then to interpret language and try to apply a precedent to a changed situation. And what the conscious contract or the discovery and agreement process does is it gives a foundation so that when disruption happens, the parties then are forward looking. They know where they start from. They say, this is what we expected. This is where we find ourselves. Now, what do we want to have happen? So they're focusing on the purpose of the relationship and the interests that they had established as the reason for the relationship. And then they have a problem solving structure framework built into the agreement itself to support them in making whatever plan needs to be made. So that's the difference, you know, that when you start talking about what went wrong in the case book, it's like, that's all backward looking, and that's not helpful to the business people.
I think that's what I found in my career has been so powerful about using a more relation-based, values-based, trust-based approach to contracting is when I'm working with my business clients, there is so much of a concern of, you know, we just want to get this agreement done, or we're friends, everything's fine, like we don't need anything. We can do a handshake agreement. We know what we're doing. We know we're aligned. And before I ever went to law school, I had started my own business with a business partner, and we had asked each other a number of questions. We had spent months before we decided to go into business together. And then we had big conversations before we took the leap and said, okay, we're really doing this. We thought we were totally aligned. And yet within 6 months of opening that business, we almost could not speak to each other. You know, it was full of passive aggressive behavior back and forth between us. And there was so much lack of communication and an inability to talk about conflict that allowed the conflict to just build up and up and up until it was getting to a really big point. And the reason was because when we used language, I'm not talking about legal language, contractual language, I'm talking about human business entrepreneur, like just the way we use words with each other, we did not have the same meaning or connotation or definition of what that was. So when we said, you know, this is what the store is going to be designed like, and we would use words to describe that, and we'd say, yeah, exactly. You know, we didn't realize that actually we had two totally different visions in our mind of what that would look like. And so not having something, you know, in advance, I had never considered going to law school at that point. I didn't really know a lot of lawyers, and we never spoke to a lawyer in setting up that business. And I remember having like my head down, blinders on, thinking if I'm going to talk to a lawyer, they're going to charge me $500 to sit down. And then they're going to tell me all the things I need to do and say that'll be $10,000. And this is a very small budget, you know, my personal savings. We didn't have a lot of money to put into this business to get it started. And so we never talked to anybody. I looked online, got a template of some agreement, something to create, you know, the business, and we signed it. And neither of us understood any of those terms. And not having that part of it, which in conscious contracts is the addressing change and engaging disagreement section, where we're figuring out in advance, what are our conflict styles? How are we going to talk to each other? How are we going to flag these conversations when there's a small tension so that we can move through it and flow into a conversation and address unexpected change? That would have allowed us to process things so much better and work through and figure out whether we even wanted to set this up together or how to move through the conflict we had. Whereas right now, the way that I see traditional contracts being used is you create this agreement and you just, you know, have a piece of paper and say, you sign this right here. And so I'm going to enforce it against you. And before you do that step, there's no other step for you to take. And this goes beyond that mediation or arbitration clauses, which are sometimes just used the same as litigation or courtroom. You know, I'm holding you to this. That's not a conversation.
Jacqueline, do you think we need to talk about the structure of the conscious contracts process at all? Because I wonder if, you know, we're all very familiar with it. And so for us, this conversation makes a lot of sense, but there may be a lot of questions as far as just sort of a basic framework. Has this been made available?
I'd love to jump into that. But first, Gabe, I want to hear your perspective, because at the beginning of the year in January, you had no idea what conscious contracts was or anything. And so I'd love to hear your perspective of like what you were thinking about negotiations and contracts before that, and then maybe take your take of it, and then we can dive into more detail of what the conscious contracts process is.
Yeah, definitely. And Alalá, I think you're reading my mind because, you know, as someone who has been where a lot of our colleagues are today, I think it's helpful to have that structure and just kind of a mental framework of what we're actually talking about, something to grab onto and grab a hold of. So, you know, as a law student, I actually was taking another negotiation course this semester in parallel with this clinic experience. And one of the things, you know, you learn intro negotiations are competitive bargaining versus collaborative bargaining, and just some of those basic frameworks. And honestly, a lot of the class is learning about preparation and how to, you know, I would say exploit might be a harsh word, but to, you know, leverage different pieces of information. What will you share? What will you not? And of course, there's the collaborative side where, you know, you look to build consensus, but even that in some ways has a pretense of, I would say, mistrust, or trying to either not get taken, or to take the other side and really do well in a negotiation. So that was probably my initial framework for negotiating coming into the class. And when I learned that we were going to be working with clients and really taking them through this process that Alalá will review and kind of give a framework for in a moment, I wouldn't say I was skeptical, but I was really curious to see how it was going to play out. I had never really thought about this different type of paradigm. And we actually had the opportunity to read the book and to really understand and kind of dig in, and then a little bit of practitioner teach our clients as we were going. So we weren't much further along in the journey than them. But I think what I would say is it's really to me a simple concept of the more agreement and understanding that you can garner up front. I don't have the numbers to back it up. I know law students are afraid of math in a lot of ways, but I think there's probably a very strong correlation between actual enforcement of those types of agreements. So just to think about contracts instead of like a weapon or a defensive, like a shield, thinking of it more as, again, like this collaborative process that two parties, a lot of times they see something in each other, they have a need for each other in some way or some level of cooperation, and no one enters an agreement, as Jacqueline mentioned, no one enters an agreement looking to see it blow up. So I just really appreciate the shift and the change of perspective that really puts the emphasis in the work up front to really garner understanding and that agreement before we kind of rush to these defensive, weaponized types of maneuvers. So I'll kind of leave it there. I hope that gives a good overview. And Alalá, maybe now's a good time to, now that we've overwhelmed everyone with our to give them a framework and bring them back to the real lawyerly tactical piece.
The nuts and bolts, so to speak.
Yes.
Thanks, Gabe. Yeah, just to clarify what I'm talking about, this is understanding the contract negotiation as a relationship design process. In addition to all of the things that we've talked about predictability and clarity and accountability, all of that is woven in. But what is acknowledged is that this is going to be a relationship. It's going to be an ongoing relationship. Even if it's just a transaction, how the transaction goes is a relationship. So we want to talk about that and to approach it from what is the reason? Why are we coming together? Why are we choosing one another? What is the benefits we see? And we do that in the conscious contracts process. I've sort of identified two key pieces that need to be in every conscious contract. And the first is what I call a touchstone. And this is where the parties talk about the purpose. And they talk about both their own purpose, about why they're interested in doing what they're doing, what drives their bus, whatever their vision of the future of a better world is that they're trying to serve in the sort of the big picture, and then the mission, the reason for this relationship, the reason for this contract, what it is they're trying to achieve together. So vision and mission, and then values. And values gets to be kind of a funny little word. And so sometimes I call that keys to satisfaction in a working relationship. So in the touchstone, and this is a really brief, quick, in the touchstone, this is actually expressed by the parties in writing and included kind of in the way the preamble is in any contract, instead of whereas this, that, and the other, or instead of background, this, that, and the other, or in addition to all of that, we have this touchstone where they've expressed their vision, their shared mission, and the keys to satisfaction to being in the relationship. And I like to sort of characterize that whole touchstone as the design criteria that they're going to use. These are the design specifications for problem solving. later down the line, so that when some disruption occurs, they will use this information in the Touchstone to help them evaluate whether a particular proposal or solution serves the original purpose, serves the party's interests and needs as expressed, and aligns with the values that they have and their keys to satisfaction, which can include financial viability. Then the second part that is linked to the Touchstone is what I call the ACED, addressing change and engaging disagreement provision. And this is where the parties themselves set up a conversational procedure that they're going to use if they find themselves in disagreement, or if disruptive change occurs and the plan they've made that's embodied by the terms and conditions of their contract no longer makes sense to one or both of them. You know, something as we have seen recently with the pandemic, there's just no such thing as certainty. And so what they need is a sense and respond sort of process that they can use. And so this ACD will have the steps for how to call the conversation, how to have the conversation, and how to check in on the conversation, to, you know, on the result of the conversation later, whatever's needed, so that they themselves can come together and have a structured conversation, so it has a little bit of a guardrail on it, that is focused on, and this is in the ACED, focused on bringing them back into alignment and serving that touchstone, those design specifications that they set in the first place, and can be used to reset those design specifications if they need to. So all of this is like taking the mediation or the restorative process, embedding it into the contract so that it's available and ready should it be needed later. So, and then the final piece that I use, just because, as we all know, the contract is the private law of the parties, as long, and will be enforced as long as it doesn't conflict with the statutes or the larger conventional law, is to put in a condition precedent so that they contractually obligate themselves to use the ACED before they do any other dispute resolution process. So that helps just sort of support them in that heightened emotional place that we often find ourselves in, that businesses often find themselves when things have really gone awry and there's financial stuff on the line. So the Touchstone, the ACED for engaging change and disagreement, and then the condition precedent for making sure that they actually use their system before they move to the contractual, to the conventional. Have I been clear, you guys? Is that enough?
I think that's a great start. And I just want to flag, because I saw in one of the questions already, somebody had raised collaborative contracts. And so I think, just to clarify, there is this whole movement towards bringing in this relational trust-based approach to the contracts that we're seeing across the legal field. And there's many different ways, you know, collaborative contracts, relational contracts, conscious contracts. Conscious contracts is a trademarked process that has these specific component pieces of the Touchstone and the ACED that Linda has co-created. And the book that Gabe was mentioning is, again, the Discovering Agreement book, which is what both Brittany and Gabe have read as part of our course.
Right. And the difference, I mean, you know, there's a lot of growth happening around the collaborative process is its own kind of process, but it has the same focus. A collaborative contract may not have these kinds of provisions in it. And I saw something about the URI process of getting to yes, you know, that's the ACED part that could be embedded into the contract. What is unique in the way that, you know, sort of I see conscious contracts or discovering agreement or process is that we're using all of these modalities to build and design the relationship and even pre-qualify the parties to make sure that they are aligned before they actually get into the agreement and get into the contract signature part. And then we are using the contract to create a framework so that it is always there and it is part of the DNA of the relationship going forward. So it's building it into the contract, whether it's done through a collaborative law process or whether it's done just in a normal situation where one lawyer, one party, you know, and the two lawyers and parties are negotiating, or whether you have one facilitator helping the parties come up with their own contract, all of that. What's different is that we have specific provisions in the contract that are designed to help them sustain the beneficial purpose of their contract and the enjoyability of their relationship.
Gabe and Brittany, I don't know if you've read yet, Getting to Yes in Law School. I'd love to hear your thoughts in reaction of how is this similar or different, or what you want to draw out about conscious contracts.
So I was thinking about that as we brought it up, and it's been a while since I've read the Getting to Yes. But I think the negotiation piece in this conscious contract process, especially with addressing change and engaging in disagreement, how it occurred for me was that many people probably don't realize that they have the opportunity to create their own, like you said, private law. Like, how are we going to handle this? And I think it becomes more of like a system of checking off the box. Like, you go to an attorney or you print out a form and it's like, oh, okay, do I want to agree to arbitration, mediation, litigation, negotiation? And it's like finite. You have to choose one of those boxes. And then I think a lot of people don't realize that there's this alternative way. And in that alternative way, you're kind of like the puppet master. You get to decide how you will engage in that conflict. And it could be as simple as, you know, like, we're going to go out for coffee and, you know, we're going to talk about this, or we're going to take a break, or, you know, it doesn't have to be like, we're going to get a neutral third party and that third party is going to follow these rules of evidence. And most people probably don't even know what that means. And so I think that the negotiation and the Getting to Yes, you know, book is really great strategy for like approaching a negotiation so that everybody kind of walks away feeling whole and complete, for a lack of better words, or, you know, that's the endeavor. And I think what happens with the conscious contracting is you're going in saying, like, we want to be whole and complete in our partnership. And how do we do that? And how do we be whole and complete if we no longer want to have a partnership, or exiting that partnership? And how do we do that conflict with integrity to how we see ourselves and how we value not only ourselves but our partnership when things are good and aligned. And I think that that's the difference, is it's a lot of work, not on like approaching from an individualistic perspective, maybe thinking about what the other person wants as leverage, or to kind of like bolster your position, but rather to say, like, I'm intrinsically interested in what you're bringing to the table, what your positions are, because when entering into a partnership with you, I'm aligned. You do well, I do well. You do bad, I'm not going to be so great. And so that negotiation piece is, how can we meet in the middle and realize our aligned values serve each other, and continue that throughout our working relationship, or whatever relationship that looks like. I think when you think of Getting to Yes, that negotiation is still a us versus them like mentality. And I think with conscious contracting, it's a we, like, how are we going to do this?
Right.
And
And Brittany, I think it's important to point out that, you know, this is not the end of all conflict. What the difference is, instead of us versus them, is with a conscious contract, what you're examining is me versus us. Okay. And so the interest of each party is still key and core. And the question is, are we better together? And how can we make ourselves better together? And then how can we sustain that benefit and increase that benefit going forward? And how can we use our conversation and our creativity, and what can we put in place in a document that's going to support that? So I think that's really key, because a lot of people I often find that clients are like, that's really nice and altruistic, but don't you think it's a little unrealistic as far as human nature goes? And the answer is it's shifting. Instead of us versus them, it's me versus us. Like, this is my evaluation. Is this going to work? And if us is stronger than me, us is it. Now let's make that work.
Yeah, I want to clear up a few things, because I'm noticing in the questions, there's a bit of misunderstanding about conscious contracts not following principles of law or legal precedent, or being something totally separate. So when we have a traditional legal contract, what we have is a lot of legalese of, the parties heretofore named this shall relate in this manner, and then goes through, this is what the agreements are. And most of that is a lot of fine print. It's documents that have been passed down in law firms over and over again. There's components that aren't necessarily relevant. And frequently parties don't understand what they're agreeing to. And I have clients who are adamant, like, I can read through this. Yes, I can understand the words, but I don't think people understand the import or why this paragraph is here or why it's written here. And most of the time as attorneys, what we're doing is we're saying, we're spending our time explaining, basically what this contract says is you're going to pay them this much. They're going to provide you that. They're going to do this by then. This is what happens if you don't do this. And if you have to translate all of that, first of all, there's a plain language approach to this of, why don't we just write our contracts that way if we're not translating it? And then if you think of that traditional contract, the parties don't really know whether they're aligned. They think they are, but there's no process that we normally go through as attorneys. We'll raise some red flags, we'll ask questions, we'll speak to both parties, but there's not a really engaged thing to discover at a deeper level. Is this aligned with what the parties want to be doing, or is something a better fit? And this is, even for the best practitioners, I think unless you have a very in-depth process, there are layers you're missing. And then you'll create the contract, the parties will sign and go off their ways and want to help. Nobody looks at the contract again. Maybe it happens to go right or it goes wrong. And when it goes wrong, once you get into that court of law, as one of the questions was asking, a judge is going to look at this contract that does not explicitly say the intentions of the parties at the beginning or describe their alignment fully, and is going to try to interpret this and figure out. Whereas with a conscious contract, when we're going through in more of a plain language, the intention is to make it clear for everyone. This is why we're coming together. This is who we are. This is how we are aligned. This is what we are thinking about when we're making this agreement. This is explicitly what we're agreeing to. These are the steps we're taking afterwards. And it's just so much clearer that if you would end up in a court of law, it's much easier for a judge to figure out, ex ante, this was the intention.
I want to be really careful also about the question about interpretation by the court of a contract, of conscious contract, because that's a good question that I get a lot. Is the other side says, this is just not, no court can interpret this. And the thing is, the Touchstone and the ACED are never something the court has to interpret or apply. Those are created by and for the parties, and the parties who create it are the ones who interpret it and use it together. If the whole thing fails and they end up in court, then the terms and conditions are still there. and the court can interpret those terms and conditions. It's helpful to have the legislative history, as Jacqueline was pointing out, but the court doesn't have to interpret anything as far as like holding someone accountable to their values. That is not going to happen in the court. What's good, they're going to be looking at those terms and conditions. The shift is that we understand, and the parties understand, the terms and conditions as an action plan, not as a rule book. It is the action plan, it is the rules they expect to be following, given the universe they are forming their relationship in. But when a disruptive product comes to the marketplace and those terms and conditions don't make sense because that action plan doesn't fit the new universe, they don't have to go to court, or they don't have to find lawyers and start battling about who's going to bear the loss. They can immediately move into, well, interesting. That's not what we expected at all. This is what we're trying for. How can we adjust? How can we bug fix our software so that now it does, again, what we want it to do? So this is this kind of flexibility. And I really like that difference between predict and control and sense and respond, because that's what this contract is built to do. So don't get freaked out about thinking that the conscious contract is somehow not going to have warranties and representations in it. It very often looks very much like a conventional contract it's a conventional contract plus, and it is formed because the parties have really looked at their relationship, their intentions, they've been clear, so that clarity is there, that predictability is there, and what they're holding themselves accountable to is their own interests, not to how the system is going to interpret some language that was written that they never really understood. So that's kind of where I'm at with that. Is that helpful, do you think?
Brittany,
Gabe, you're
Gabe?
laughing. Talk to me.
No, I appreciate it, because I think it's such an ingrained concept, and it's so different, right? Like it's definitely a paradigm shift. And even going back to one of the original questions around like the getting to yes versus this, I kind of think of getting to yes as more like tactics, and I think of this as definitely more an overarching process and way of approaching things. So maybe more of a mindset. And I think one of the neat things is that it really is customizable to the parties and how they operate. Brittany and I in our clinic this semester had very different clients that we were assigned. My client was basically like a very early stage startup. It was people who had not even incorporated yet, but wanted to, they knew that they wanted to work together. They have a product and a plan, and everyone has different roles. But it was eye-opening to see how little they really knew about each other, and also just their working styles and ways that they wanted to approach, potential conflict that does come up. And I think it can be the conscious contracts process can be very valuable at that stage when it's so new and people are still feeling out the business relationship and who's going to do what, and what really makes this person tick and what sets them off. So there's a lot of discovery that goes along with that. I think the part that maybe we've alluded to or not even said is, sometimes the best agreements are the ones that aren't made. And this process is going to get everything out on the table. So if your client is working with someone, or you have two different parties that are looking to, launch a business or some initiative or joint venture together, this is really going to force them to think about, what are all the specifics of the other person. And I want to know this up front before I do, sign on the dotted line, before I do invest capital and time and opportunity costs. So I think there's really, practical pieces to this, and maybe by nature, our panel here is more talking about the concept, and it might feel a bit nebulous to, you all as practitioners. But as someone who went through, a clinic, I can see the value. And, I think there were definitely moments that were eye-opening for our clients when, they got to learn a little bit more about their potential partners, and, talk through, hey, like, that's not how I operate. And how are we going to deal with this? Like, what are our expectations? And as Alalá has mentioned as well, thinking about it as kind of like a mission, vision, like very positive, very optimistic. And then your ACED as the second part that really has the elements of accountability in terms of how we get to, that mission and vision. So, from someone who, admittedly limited experience, I think there was a lot of value, and there can be a lot of commercial value just in going through the process up front, whether that bears an agreement or not. That's kind of part of the beauty of this as well.
Yeah, I just want to, since you said the word accountability there, that just reminded me of something Kim Wright, a co-teacher and the other half of the conscious contracts process, co-creation, said in class was, when you're talking about, it's not how are we going to hold each other accountable, but how am I going to hold myself accountable to the agreement that we're making together? Because there really is a shift in the way that when you have parties coming together to create a contract, there is so much fear and uncertainty. So by going through the conscious contracts touchstone process first, that's really where we're, kind of taking people who might be here on opposite ends of the table, even though they want to work together, but emotionally, there is ingrained in our society this separation, this defensiveness. And the touchstone process is bringing us closer together to discover and build that trust up and alignment. And if they're still aligned by the time we're done with that, there's the ability to open up more honestly and transparently about how you are in moments of conflict. And we don't normally have those conversations. And when we don't, moments of conflict come up, and either you have an avoider in the contract and they will just ignore it. You have somebody who overcompensates for everybody else and takes on everything, or eats the cost, or does more of the work. Or you have somebody who blows up and is angry, and that each of those causes their own friction and fissure and disrupts the contract from being achieved and fulfilled. And that's what starts to lead you down a path of litigation. And so if instead, when we have this beautiful space of trust between the parties built, are able to have this conversation where they can open up about, what, I avoid conflict, like that's how I am. And I think we've had our students experiencing a number of different experiences over the years with clients of how different each of our personalities are around conflict, and what, even when I'm conflict avoidant and somebody else is conflict avoidant, we may mean different things by what's helpful. How do you reach me? How do you talk to me when I'm ignoring your calls or I'm scared to pick up? How do you make sure that we move through this? And this process, that's to me what feels so unique about it, is opening up and creating that trust and conversation in a way that I don't think we normally touch on in the legal field.
Yeah, Jacqueline, I want to also, because that sounds very personal, and I don't want to give the impression that conscious contract is only for person-to-person contracts, but that it's actually, this is applicable and useful and beneficial corporate to corporate, business to business, because the in-house experience is that the lawyer is the one communicating with the other side, and the business people are there, and the business people are doing their thing, right? And that's all happening. And those emotions are a feature of this, but how to deal with the relationship of a corporation to a corporation. And this is absolutely doable with the same process. It just requires the humans in the corporations to really articulate what are the design criteria that we are going to use to evaluate proposed solutions and to any problems that we encounter. And building that in, and also building in their proprietary procedure for bringing the problem up, for what they need to bring to the meeting, where the meeting's going to be held, how they're going to actually conduct the meeting, and what sort of decision making they want to have around that based on the design criteria that the corporations have. And I also want to point out that very recently, like just in the past week, the World Commerce and Contracting Organization did a symposium on what they call relational contracts, theory and practice. And while it didn't specifically discuss our particular process that we're all familiar with using, that kind of developed out of necessity, there were presentations of papers that are talking exactly about this same thing. And there was a discussion of how Pfizer, in its contract with, I think, biotech, in the rapid development of this vaccine, BioNTech, that was it, they needed something that was, not going to take a long time for them to come to agreement on. They needed to be able to use what Stephen Covey calls the speed of trust. So it was important to them. So these big corporations first examined trust, built trust, supported trust, and talked about focusing on the purpose and how are we going to be transparent with each other so that we can move this forward because are beneficial. So I don't want us to give the impression that while it is a beautiful thing and it's really almost a spiritual practice when you're dealing one individual to one individual in their business relationship, or a family business, or even a marriage settlement agreement where you have two parties who are dissolving a marriage but continuing a relationship because they have children. Having these kinds of provisions are very helpful and very supportive to the individuals, but I don't want to give the impression that this is not applicable at a scale.
Yeah, I think also the cross-cultural aspect of it. So where I was talking mostly about that person to person, because I mostly work with founders, partners who are building businesses together and deciding whether to form or to create their agreements. There's also the value of that discovering conflict styles cross-culturally. And I know, Brittany, this was something that came up in your client case this semester, because you had an organization that has like 20, 30 independent businesses collaborating across the world. And you had a succinct group of, I think about 5 of them were the head core team that you were meeting with. And do you want to share a bit about that experience of the cross-cultural aspect there and how that played in with the conscious contracts process?
Yeah, so it was exactly as you said. So there were multiple independent contractors who came together for consulting at a larger global level. And specifically, the team I was working at had members in Tokyo, on the West Coast and on the East Coast. And so they had actually been established and working together for 15 years, like a very long time for them. And I think it was exactly right. It was part of the process was asking the questions that don't get asked during normal contract negotiation, if we will, which tends to be very black and white. What are you willing to pay? What timeline are you willing to accept it to be done within? Instead, our conversations were more like, okay, well, when we're talking about conflict, like what motivates you? Like when do you feel good within your team? And one of the Japanese consultants had said, oh, I really value praise and appreciation and being acknowledged when I am doing well. Like I want that feedback. And his partner of like 15 years was like, I never knew that. Oh my God, like how transformative would our working relationship be if I just said, hey, like, that was really great. Thank you. You did a good job there. And he had said, yeah, I'd probably show up more of myself when I got that feedback, and possibly prevent some conflict where he was feeling underappreciated or overlooked in his capacity. So does that prevent arguments or tension or the need to engage in conflict at a higher level? No, but the conversation and the process of just opening up, like especially cross-culturally, where I think, the conversation was in America, sometimes it's like a little cross to be like, good job, you did it. Like everybody, the teammates were saying, like, we don't just throw out compliments in America. And in, Japan, he's like, no, we tell people when they're doing a good job in Japan. And I know that's a very simplistic way of saying it, but it's exactly that. It was just having an open and dialogue about, one, how two different people view the same thing, and then two, agreeing about how they'll act or not act within that construct. It didn't necessarily have to do with specific provisions, but it allowed two people who had been working together for a very long time and who were dedicated to continuing that, to have some tools or understanding of how to maybe keep that solid working relationship and build upon it as they go.
Another thing about accountability that you talked about, Jacqueline, is the difference in what they're being held accountable to. And for me, this arises out of the fact that no matter what we have out there and say, like, we're being held accountable to the terms and conditions, the reality of life and human nature is I am held accountable by myself to my interests. And so I am going to maybe justify serving my interests by how I rationalize their fitting in with whatever terms and conditions and accountability to the terms and conditions. But the reality, when you get right down to it, is, again, we're back to the me versus us. And so what the conscious contract process actually does is get the parties to say, this is what I'm holding, this is what my key interests are. This is what I'm going to use as my criteria to evaluate if this is a yes or a no, if anything is a yes or a no. And that's just honest. And it might as well be out there and truthful. And then you don't have the problem of me trying to hold you accountable. I can just say, okay, you said this was like a key criteria for you. Help me understand how what you just did matches up with that, because I'm not seeing it. And the conversation is very different. And you are more likely to have a productive and creative outcome. This is the other thing I want to really highlight is how the conscious contract, the discovery agreement, the process even is about understanding that conflict is natural and it's a result of growth and change. And so we want to harness its creative potential. And that's what this is about. Not turn it into a disastrous, destructive force, but to say conflict means something has changed and we need to upgrade. Now let's create that upgrade.
Yeah, and Linda or Alalá, you used the process word there, and I think this is going to help with a couple of questions that I've seen come in. We mentioned before, you can have all of your contract terms. We're not challenging anything of legal precedent or principles of law or anything with this. What we are saying is there is a process you can take to facilitate finding out before anybody signs an agreement, are they actually in alignment? And a process that goes beyond what I have at least seen in any of the other practices, or even from experienced transactional practitioners, what is being used today. That process, once there is alignment in what you create there, you then go through your terms of agreement. You're still creating a contract, those terms can look very different depending on the parties, their positions. Are these two large corporations? Are these two individuals creating a family parenting agreement? There's going to be a lot of diversity there. And I do think that aspect of plain language is really critical throughout all of it and is an integral part to this process. And while plain language has been around for a long time and mandated by a number of people, we are not using it. We're not using it in the court systems. We're not using it in our traditional contracts. We're not using it in our small, big, major corporate law firms, in-house counsel. There are so many conferences, especially in the past couple of years, I've seen come up where it is clear that even if we've taken steps forward, we're not taking that leap of actual plain language. And there are places all over the world that are starting to make headway on this. But that plain language is so important because it allows us to create the terms of the legal contract and agreement in a way that the parties understand. And so they are more likely to follow through on fulfilling, because from the beginning, they understand what they're agreeing to. And this goes beyond what is, every lawyer feels it's their responsibility. Of course, I explain the contract. Of course, my clients understand. Of course, the parties came to agreement. And I think I have a hard time explaining without taking somebody through the process of how different and distinct it is. But we're not at all ignoring those explicit components. And that ACED part just allows you to facilitate communication so that the conflict and tension does not arise to the level, or doesn't arise so quickly to the level at which somebody pulls out the thing and says, you signed here, we're going to court. I'm going to now, we've separated and we're antagonistic again, and I'm going to force you to be held accountable to this agreement. It's a way where the trust is built so that they can meaningfully have those conversations. It's not a third party enforcement. It's not somebody outside coming in and saying, you have to go through this mediation, you have to show up at this date, you have to do this. Mediation could be a part of your steps, but there's really this important aspect of the parties themselves are agreeing and co-creating what their conflict resolution process is. And so they have buy-in, they're committed to it, they want to create and participate in that. It's not something from the outside that you're putting in where it's very easy. We see people checking the boxes, showing up, being antagonistic, being adversarial, or not coming to any agreement, and you're just inevitably delaying the day that they get into court.
Well, and this is, for me, leads into something very important, which is that one of the reasons that I developed this process was because it was my experience that when we came to court, or we came to a lawyerly sitting around trying to reach a settlement thing, the application of precedent and the application of the contract law, case law, was about trimming out, to a large degree, the context and complexity of the situation the parties found themselves in. And it took the power of decision-making almost out of their hands in a way where the conscious contract and the ACED provision and process gives them the opportunity of self-determination, because the parties themselves are the most appropriate ones to embrace and be able to work with the complexity and the context of their individual situation. And that's natural. The courts cannot do that ad hoc with every contract that comes before them. They have to trim out context and complexity in order to just move things through. And so for the business people involved, it's really a great opportunity. And I'm not saying that we're eliminating litigation. I mean, I often say, don't let me take your hell away from you. If you insist, you can litigate, you go for it. But the business people have business imperatives that litigation destroys and does not serve. And, you know, there are times when the courts are doing something that is necessary and the courts should be allowed to do what they do best. But embracing complexity and context in an agile, responsive, you know, business-oriented way is not what courts do best. And so this actually gives the parties that opportunity, builds it in as a precondition before that ultimate hammer comes down. And that hammer is there. If it's needed, I've got nothing against it if that's what's really needed. But so many times I've heard judges saying, why are you guys here? How come you're not just talking to each other? What's going on? You know, so that's kind of, it's that self-determination piece. That's the other value I see. And so speed of trust and self-determination, sense and respond, agile, practical, creative. I think it's got a lot to recommend it without coming at all in conflict with our conventional case law, statutes, processes. It's just letting the parties really design for themselves what's going to work.
Gabe, I'd love to hear, and Alalá, feel free to, for our audience, couch all of the following answers, because I kind of want to dive into that almost spiritual process part of this, because our students in the clinic go through not only reading and learning about this approach and the business application and the techniques that are being used across the field, they also go through and create their own personal touchstone. So they understand what they're going to be asking their clients to do. And then they create a firm with other classmates in which they have to come together and create an agreement and go through the whole process and then work with the clients. And I'd love to hear from you, Gabe, and then you, Brittany, as well, of like, what is this experience like when, you know, you hadn't heard of this before, and what you were thinking when you first did it, and then what you've thought of now after taking your clients through it.
Yeah, I mean, I really, you know, for our course, I love the way it was structured in that we really learned by doing in the first half and did this, you know, personally. And I think that's a hugely valuable part to the process, even if you're doing this out in the real world. So just getting like a grounding of what's important to you, you know, your own mission, values, your own vision, those types of things, I think is always valuable. And, you know, sometimes it's maybe people have done it in a different form, but it's been a number of years, and to kind of update that, or, you know, check in with yourself to even just say, hey, like, this is who I am as a person. This is where I'm going, who I am professionally, what's important to me, and you know, how I see the world in some ways. So I really enjoyed that process. And then the ACED portion, right? Understanding again some of like what makes you tick, some of your what ticks you off, as some people might say, and really just almost like a guide to communicating with you. If you were to present to someone else, think of like even a loved one or a colleague or whoever it is, whatever context. If you were going to give them a guide to you, that's kind of how I thought about that process. And so we did get to exchange those types of things with our other colleagues, and then came together as a group to really blend a lot of the different visions together into one common, for the purpose of the seminar, one common firm goal. And, you know, I enjoyed that process because there's a lot of iteration. And I think it did allow us to do some internal, you know, evaluation, and then bring that external focus and kind of put, you know, pen to paper, and, you know, as we've been talking about, have something to hold ourselves accountable to. So, you know, I really enjoyed that process. I think without it, it would have been very challenging to just launch right in and start trying to work with clients. So getting to have that experience was really formative, and allowed us then to, again, kind of take and see what we learned ourselves, and do it with our clients in their group setting. So yeah, I really enjoyed that process, and I thought it was valuable. I mean, my Touchstone is something that I will continue to look back on as I move throughout my career, even just to check in with myself and make sure opportunities I'm either taking or turning down or deciding on align with that. And I think if nothing else, it's a hugely valuable tool, and not everybody has that even in their professional lives.
Brittany, do you want to chime in? You need to unmute, darling.
Yeah, so I agree with what Gabe said. At first, I think that personally, I have to go through something myself in order to like walk through something with somebody else. So it made perfect sense to do our own touchstones before we did one with our firm and then with our clients. And as Gabe said, I think it was like so helpful for me to reflect on what my own expectations were of myself, and how that showed up for me. And I think we've talked about it in several ways, but it's 100% manifested as an accountability thing for me. So, I was very deliberate in how I drafted my own touchstone. And I frequently go back and visit it to see if I'm holding myself accountable to who I say I am and what's important to me, or if my touchstone is out of accountability, like integrity, meaning like I've changed, the world has changed. So let me revisit that component. I think it's really helpful to do it on an individual level and then bring it to the team, because if you are unclear about your own values and expectations, or even if you're just kind of like wishy-washy on your purpose, it's really helpful to kind of sit with that and figure that out on an individual level before you bring it into a partnership, because you're gonna ebb and flow as partners. And I think just being more clear on where you stand is super helpful. So that's why that spiritual kind of work on an individualistic level is kind of important, because it trickles into the team. And I think, like you said, Alalá, is like, even when you use this in a corporate way, you got to find the people of the corporation. And that's kind of how it was for me. It was like this like inverted pyramid where I'm at the bottom of it, and it's like my values and purpose and mission and how I engage and handle conflict was essential as we put the building blocks of how that interlaces with other people. I found it so valuable in this like in this capacity, like this moderated negotiation clinic, but I also took it outside of the law. And like one of the things I was discussing in the class was I did a touchstone with my 4-year-old son. Right. So like, as funny as that sounds, I was like, all right, like, let's be clear here. What do we love to do together? Like, what's fun? What do you want? What do I want? And in an extremely watered down way, I kind of took it and ran with it and was like, okay, if I could see the impact of this work in contracts, and you bring this value system as one component of a contract, I think you could easily branch out and use it in other areas, even within the law, not necessarily just contracting or transactions. But I found it super rewarding, and I'm forever grateful, because even outside of the terms of conscious contracting, the work is really valuable just for interpersonal relationships and how you interact with human beings. So, yeah.
I think one of the things that I have really noticed about having a touchstone as an individual, and about as a lawyer, having my own touchstone and having an understanding of my client's touchstone, whether no matter what I'm doing for them or with them, if my client has a touchstone, if they have talked about the vision of a better world that drives their bus in everything they do, if they've talked about the mission, the thing that they're trying to do. And if they've talked about their values and they've got that expressed in writing, because you can have a sense of it, but then when you start writing it, you discover you need more clarity. Once they have a touchstone, I call that their seat of power, because ever after, they are less susceptible to emotional manipulation in a negotiation or in any relationship, because they are no longer responding to what it means that that person said that to me, what it means about who I am, who they think I am, or any of that. All that I have to do is say that other party or that person said or did X. And then I go back and I look at my touchstone and say, okay, is that acceptable or unacceptable as aligned or not aligned with my touchstone? And so I'm less likely to respond to, you can't talk to me that way, and I'm not going to let them get away with that. That's just not even part of the conversation. So my clients in negotiation, because they have their touchstone to check and evaluate, it is the thing that they are using to evaluate options and evaluate proposals, they're less susceptible, as I say, to the manipulations that are often present in negotiation type situations. And the other thing that I think is really key is that as lawyers for ourselves, we are asked to stand at the intersection of rationality and emotionality with a client who is often going through the most stressful time in their life ever. And we are expected to partition our emotions, because emotions are not trusted, you know, because we're supposed to keep ourselves separate and stay completely rational and logical. And the ability to partition the heart is an illusion, because as I often say, the heart will manifest. It will manifest. If you do partition it, if you do try to suppress it, it's going to manifest in a subversive way, right? And that's why we see so much substance abuse and suicide and things in our profession, is because we are so busy spending so much energy partitioning that heart. And what this process does, the touchstone, the framework for having fraught conversations, what that does is it allows the heart to integrate and to take a role that is not subversive, but is actually supportive. So as far as the spirituality of this, you know, I would describe myself as a deeply spiritual person and an incredibly pragmatic person at the same time. So that's kind of what I'm interested in. And I think that's really captured in this process.
Well, I feel like I could keep talking forever, but I do want to dive into some specifics of the questions we've had so far, because I think there's some good points. So let me just scroll through to see the order we want to pull these out in. I think a couple people have asked about some specific examples or how to learn some more about this. We'd like to be doing a CLE sometime in the next year on this topic, so we can provide some more in-depth training on this. But to start with, absolutely reading Discovery and Agreement is a great layout of not only the component parts, but some examples of what it practically looks like in an agreement.
It might be reassuring to let them know that the American Bar Association published that book. It's not, I know lawyers, I'm like, here's the credentials.
Yes, yes. The other thing is, you know, we had somebody asking, you know, how are we able to bring this consciousness in this sort of collaborative approach where one party has or believes it has a stronger bargaining position and seeks to impose its desired provisions? And they followed up with an example of, you know, there was a time where they represented a party who had the weaker position and came across an important but ambiguous clause that his client would often choose to leave the ambiguity rather than having it clarified in a manner it knew it would not like. And so this leaves it the ability to fight another day. And I think this is just such a great example of our traditional approach as lawyers and how we often deal with contracts. But Alalá, do you want to speak to that at all?
I have some interesting ideas about that. If there is an ACED in place and a touchstone in place, then leaving it ambiguous to fight another day is just fine, because you know what your criteria are going to be for evaluating an acceptable solution. And you know what your process is going to be for having that conversation. So you don't have to solve that problem up front if you don't want to, but you will have had a conversation with the other party that gives you an idea of what they're like to work with. That's sort of a beauty. I have to tell you, I get thank you notes when deals blow up. Because my clients are like, thank you for letting me see the real them before I signed that contract, because I would never have wanted to do that. And in the power differential question, just to address that, and I'm just really speeding through this because of time, but the power differential question is, if the party with the more bargaining power imposes, in effect, coerces the other party to agree to something that they may or may not really feel comfortable with, what that does is not create an advantage for the party with the most power. What it creates is the motivation in the less powerful party to even the score, to look for a way to get around things. Okay, and that is not a good working relationship. That is not helpful. So, you know, this comes down to a pragmatic, practical, operational relationship thing. And even if, in my experience, because I've done a lot of contracts between publishing companies and authors, right? So publishing company has big formatted, we can't change anything but the number on the percentage contract provisions, and they're not going to put an ACED in, and they're not going to put a touchstone in, but we still have that conversation. My author has that conversation with the editor or whoever it is their interface at that corporation. And having had that conversation, there is you've built a kind of relationship there that is much more workable, and the author is going into the contract with eyes far more open than they otherwise would be. It precludes a lot of resentment that might otherwise arise because of just unexamined expectations, things like that. And it gives the author the opportunity to look at that touchstone and that alignment with what is going to happen with this, you know, prefabricated contract that they're having to sign, because this is what all authors sign. So yeah, it's not a panacea that's going to solve every problem instantly, but this is something that at least gives each party its own power in the conversation, in the relationship. So you know, and just by doing things differently, we present a different array of choices to the other party. So when I practice, oftentimes I don't say to the other party and their lawyer, I have this really great way of doing contracts, you're just gonna love it. You know, we don't even go there. I just say to my client, what is your touchstone? And I ask my client to share their touchstone with the other party and ask the other party directly, party to party, what is your vision, mission, and values? I want to know this. And they can have that conversation, and they can have it with or without my involvement, as far as just sort of getting to know one another and getting in alignment. And if the other party doesn't come back with any answer on a touchstone, when we get the contract and are doing a red line, we'll drop a touchstone in and we'll make our best guess about what the other party's touchstone is, because I have found that people do not like to be misunderstood, and they will correct you.
I love that technique. I think that's a fantastic part of it, and a really helpful way for when you're in a contract negotiation with a party that you don't think is going to be open or amenable to this, it is amazing just by opening up how much you can shift and crack open, because you're doing something unexpected and they're going to say, oh, wait, what was this? And especially if they're like not answering any Touchstone questions or something, if you put that in front of them and say, well, this is what it sounds like, from what we've gathered for this interaction or website, or what you've said you've won out of this is what we put in, they're much more likely to engage. And then even if they don't, even if the end contract that your client wants to sign has none of these component pieces in it, the conversation has shifted and your client has way more information on, is this somebody I actually want to sign an agreement with? And it's not to say that if the other side doesn't engage, that's an absolute no. It's up to your client to make that decision. There are plenty of times where, yeah, of course, I still want to move forward, but you can often end up in those situations where they've gathered enough information from participation or lack of participation that leads them in a direction to realize, you know what, this isn't actually aligned. So we have 5 minutes left, and I want to answer a few questions of some alternative examples, like, is this analogous? So there was a question of these Touchstone and ACED is to contractual terms and conditions, as a legacy statement of values is to estate planning, will, and trust. And I don't know if you're familiar, Alalá, with this, a legacy statement of values. I don't think I've heard of it phrased that way. I do know in trusts and estates of putting a letter at the beginning, or some addendum or additional document telling more of your life story, or what's been important to you, or your legacy that you want to be leaving. And I wonder if that's what this is here. I think in a way that Touchstone may sort of play that kind of role, because it's sort of, this is the founding principles. This is what's guiding this agreement that follows here or is integrated in here.
And yeah, I think very likely that is a true analogy, or a valuable analogy, or an accurate analogy. And again, I always go back to what the Touchstone is, and perhaps the legacy statement is an expression of the design specifications for that person's life, or for this pair of partners. And those design specifications are going to inform every decision, every conversation, every problem solution, all of that stuff. And so if that's at all helpful to answer that question.
I also had 2 more comments here, talking about some other systems that I hadn't actually heard of that are interesting. So in civil law systems, there's a hardship civil code provision, where if there's an unforeseen development that has significant impact on the economic equilibrium of the parties' relations, then that contract can be adjusted to restore the economic equilibrium. And apparently this person shares that in most civil law systems, if the parties can't agree on how to do that, the court can. But the problem is, in common law tradition, where a contract is conceived of as a way to allocate risk and should be enforced as such, banks hate having this economic equilibrium approach and often won't finance agreements that incorporate this.
Got it.
So,
Got it. Well, yeah, in this case, all you're doing is, it's very lightweight in terms of how it rests on the contract, and how the contract interfaces with the conventional system. The conscious contract provisions are there for the parties. It doesn't really impact, it doesn't sort of call on the court systems in a way that the bankers are going to get freaked out about. So that's why I say it's lightweight. It helps the parties, and it interfaces without a lot of friction.
and then one last one I want to pull in is this question about, in the commercial contracts world, of whether there should be a step dispute resolution clause. That the first step is senior executives have a period of discussion, then mandatory arbitration before going into court or arbitration. A number of clients insist on this approach in order to avoid litigation, but over time I've become suspicious of these clauses unless it's explicitly provided that nothing prevents a party from seeking interim relief, because there's situations where rights or assets or collateral need to be preserved.
Exactly.
I think we've answered that there's nothing in this process of conscious contracts that limits you from including whatever agreements or provisions you want to put in there, and in allowing those things to be figured out.
I think what's unique, Jacqueline, is yes, it's a stepped approach. Absolutely. And almost all of the ACD is a stepped approach. It's like, first, we're going to try to do it ourselves, and here's how we're going to do it. And next, we're going to, if we can't get there by ourselves, then we're going to do it with supervision. And the supervisor or facilitator is going to be there to help us stay on our process, not to guide or impose a solution. If we still can't reach a solution, then we go to joint session mediation. And if all else fails, here's our choice of forum. The thing that's different, because I like the stepped approach, you know, the executives will talk, blah, 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 blah. The thing that's different is that our ACED is tied to a touchstone. We have provided the design criteria. We've provided the evaluation criteria to which they are designing. And let me just draw a mental picture for you. It's the difference between sitting opposite one another at the table and saying, this is what I want and need, and you saying, this is what you want and need, and us fighting it out. To here on this whiteboard are the criteria that we each have to propose a solution to serve. And so now we're sitting side by side, co-creating a solution that fits everybody's needs, as opposed to battling over whose needs are going to be subverted, or, you know. So that's the unique thing that's different from the stepped traditional thing, is that we are adding those criteria and supplying them ahead of time. And even if those criteria turn out to be incomplete or need to be changed, that ACED process supports that conversation as well.
And I think it's that co-creation of, we're not having a step system that's externally imposed on the contract. It's a step system that's co-created by the parties of how they want to have those conversations. So Gabe, Brittany, last thought, last tweet.
I feel like there's a lot to say. I also just wanted to add that I feel like when you do the personal touchstone work, that's we talked about negotiations, right? And how like getting to yes. I think it's like a really great tool to use in your negotiation. Your reservation value, your alternative to negotiating is embedded in your value system. And that's something you could bring to the table as a bargaining chip intrinsically, and be completely transparent about it and say, like, this is what I'm bringing, you know, here's my cards. And as you guys were talking about it, it just kind of resonated with me that the versatility of this work is that it could be used for negotiation and contracting and dispute resolution. So I just find it extremely worthy, and I appreciate the conversation.
Gabe?
Yeah, I would just say that I think there are some real world uses for this, and if you're skeptical, I would encourage you to take a read of Discovering Agreement and give it a try, because there's a lot of room for improvement, and I think this is one avenue for that possibility. So I appreciate skepticism in the legal profession, but I would say you were curious enough to attend today, so maybe take it a step further and see whether this model can be adopted in whatever practice area you're in.
Perfect.
And as far as future of the law goes, we are seeing this trend, as is demonstrated by the recent World Commerce and Contracting Symposium. The world just moves too fast for our not to be using a sense and respond and agile structure in forming agreements and in performing and restoring agreements. So.
Well, thank you so much, everyone. We're past time. Thank you to all of the questions and everyone in attendance. We're really thankful to be able to bring this to you. And as Gabe said, if you want to know more, please check out the book. You'll have some more concrete examples in there. But we're also hoping to do a CLE this fall where we can dive into more training on the actual process. If you want to know more, just look up consciouscontracts.com. And we hope to see you all at our next Emerging Legal Paradigm Series event. Okay, thank you and have a great day. Bye.
Bye, y'all. It's been great.